Okay, hello again. This is the fourth and hopefully final installment of the lecture for February 4th. It's February 5th, and we left off with the Marbury case. I'm on slide 31. I'm sorry this is taking so much longer than I anticipated, but it does occur to me that it's maybe a silver lining of me fainting and smashing my head all to hell is that this could be a way for me to present some materials going forward when we just have too much reading to do in a given week. And next week might be one of those weeks. I really do want to focus on the Dred Scott case for the 11th. Hold on a second. Well, in any event, there's 1 week in there where McCulloch and Dred Scott are assigned for the same night, and I'll probably want to present the McCulloch in this format so you can view it at your convenience, and we could focus the class discussion on Dred Scott. So I believe that would be the 18th because that's the week before your paper on Dred Scott is due on the 25th. Okay, so let's see if I can get through this. I'm going to talk fast. This is some complicated stuff. In a little bit, it's going to get a bit complicated, but I'll try to bring this in under 30 minutes if I can. So slide 32 on the PowerPoint, it's a Marbury case and the political context. And, this is just backdrop that makes the case a little more intelligible, allows us to talk about it a little more intelligently. I begin with the phrase on slide 32, a constitution against parties. That's from Richard Hofstadter's work on political parties, the idea of a party system. What does that mean, the phrase, a constitution against parties? Well, Hofstadter's simple idea was the framers distrusted political parties, right? Factions were extreme evil. Party is a milder term for faction, so evil. They would take place. They were unavoidable, but parties were not a valuable or a good thing. So the constitutional design is intended to break up and thwart any popular, coherent, ideologically driven majority from forming and taking over, right? The Constitution is structured to fragment power and filter different interests in factions in different ways. So it's designed to stop that. We won't have a mass-based party system for another 30 or 40 years, but the framers didn't think that parties could be a good thing, a valuable thing in the system. But almost immediately in the new administration under President Washington, we see the emergence of two competing cliques of elites, two groups. They're party-like. They're not real full-fledged parties. They're kind of competing factions of elites right within the administration. Right? So one faction coalesces around Alexander Hamilton. He's the Secretary of the Treasury. Vice President John Adams is aligned with him. And the other faction coalesces around Thomas Jefferson, and he's the Secretary of State. James Madison becomes aligned with Jefferson. Madison is in the House of Representatives at this time. So Hamilton and Madison work together on getting the Constitution ratified, but then over the course of the 1790s, they split. Publius sort of splits up. And the Hamiltonians took on the name the Federalists, or the Federalist Party. The Jeffersonians took on the name the Democratic Republicans. What were they fighting about? We can organize their dispute under two very broad themes. Again, still looking at slide 32. The basic dispute was just over the visions that they had about the future of America, the visions they had for what kind of country the United States should become, what kind of society, what kind of government it should have. And relatedly, they had competing ideas about how to interpret the Constitution or understand the Constitution that went along with these different visions of America. So on the vision theme, Hamilton and Adams wanted the U.S. to become a large, prosperous, powerful commercial republic. Hamilton often used the word empire in a positive way. A large commercial empire was what was desired. Economic progress. And under Washington's administration and with Washington's support, Hamilton fashioned a range of economic policies that pursued this vision, setting up a national bank. Well, does Congress have the power to set up a national bank? Is that power given in Article 1 of the Constitution? It's not expressly given. Is it an implied power? We'll get back to that issue when we look at the McCulloch case. He also had this policy of buying up and consolidating and also funding debt, taking the state debts and consolidating them, and that would have people looking to the national government as the guarantor of their debts. And policies with respect to currency, all of these designed to foster economic growth and development. His program required a view of the Constitution that reads the language loosely to give the national government more power. Jefferson and Madison opposed all this. Both had supported the new Constitution, so basically their position was, we wanted more national power, but we never dreamed that you would have this grand design for this much more national power. And they thought that the program would benefit the wealthy at the expense of ordinary people. Their vision of America could be captured in the phrase agrarian democracy, right? So they associated Hamilton's program with the hierarchy and the social divisions of Europe and the corruption of Europe, and opposed it to this idyllic idea, this notion of small independent farmers. If everybody owns a little bit of land and property, they're independent, they're not dependent on anyone else. And that vision entailed a strict or literal reading of the Constitution so as to more strictly limit the power of the national government. They, at the time, thought that most government should be state and local government. Of course, it's the genius of the Madisonian system that once you occupy a new place within it, your perspective shifts, right? So, the Democratic Republicans had a slightly more nuanced view of national power once they were in control of it. That's how it works. So Jefferson and Madison kind of go about forming an opposition group or faction. In the presidential election of 1796, Adams defeats Jefferson in a close electoral college contest. And over the next 4 years, the polarization sort of gets worse. The Jeffersonians continue to gain support. On the next slide, slide number 33, gives you 2 links to songs from the musical, Hamilton the musical. And they involve Hamilton and Jefferson as rappers wildly insulting each other. One's over the financial plan and one's over the conflict between France and England and the question of neutrality. And it's great stuff. I just had to make it available to you. I'm sorry. So I really mean slide 34. The Federalists are getting a little nervous, and foreign affairs are part of this, right? England and France are in conflict, and there's a question about, a conflict with France and the Federalists. Not so much Adams doing, and John Marshall wasn't really thrilled with this either, but the Federalists in Congress passed the Alien and Sedition Acts of 1798. The Alien Act just changes rules about naturalization. But the most important thing is the Sedition Act. What is sedition? Sedition is speech critical of government that is defined as a crime, right? So it makes critical speech a crime. Several Jeffersonian Republicans are prosecuted under this law. It is Federalist judges who preside over the trials. The act is allowed to expire once Jefferson comes in, so its constitutionality under the First Amendment was never tested in court. This suppression fuels the animosity. And you have to remember, at this point, we have these 2 factions. They don't have an idea or an experience of a loyal opposition and a peaceful transfer of power, right? Each one views themselves as the enlightened statesmen who are being true to the principles of the Revolution and the Constitution, and the other side is an evil faction. And yes, we have to be partisan, but our partisanship is temporary to vanquish the other side that's a threat to the Republic. this is new, this idea of a peaceful transition of power. And whether that's going to be sustainable is a question. In the presidential election of 1800, Jefferson defeats Adams. And Jefferson supporters take over Congress as well. There's a footnote here I'm not going to go into. It's kind of a glitch. Everybody understands Jefferson is the presidential candidate and Aaron Burr of New York is supposed to be the vice presidential candidate, but they get the same number of electoral votes, so the election has to go to the House. It takes some 35 ballots to resolve that controversy. We'll set that aside. It plays a part in all the intrigue that follows, but the thing that is important to note here about the transition is that the election takes place in November of 1800, but the transfer of power isn't till March. So Adams and the Federalist-controlled Congress will still be in office for some 5 months, right? And a lot of scholars today think, there's no reason for us to have any period between election and transfer of power, maybe a couple weeks. January is too long, but back then it was March. And this brings us to Marbury v. Madison. And there's still a lot more factual background that isn't in the book that we have to get on the table to understand the case. I'm on slide 35. Let's start with John Marshall. John Marshall was born in 1755 in the frontier of Virginia, in the Blue Ridge Mountains. He doesn't come from poverty. His father was a large landowner and had wealth, but he comes from a kind of a folksy, down-home, ordinary folks culture. He's not part of the planter elite of Virginia. He marries well, as Jefferson did, but he retains his kind of folksy ways. Apparently was a very charismatic guy, fought and led troops in the Revolutionary War, was with Washington at Valley Forge, and war shapes him into an ardent nationalist, and he's very skeptical of the states and their competence. And he believes that the future of this republic depends on the national government being established and viable and powerful. And that comes out of his experience. War sometimes has profound effects on people. Oliver Wendell Holmes served in the Civil War. He was shot 3 times. And some people think that profoundly influenced his social and political philosophy. Maybe we'll get back to that. But anyway, Marshall doesn't really crave a career in politics. He has a term in Congress from Virginia. He becomes Adams' Secretary of State, and near the end of the term in January, after the election, Adams asks him to be Supreme Court Justice. This is after he asked John Jay to do it. Jay had done it before and left, and he asked John Jay to take over the role again. And Jay's response was, why would I want to lead a body that has absolutely no role and no power in American governance? I don't want it because it's insignificant and irrelevant. And, Jay wasn't wrong at the time. So John Marshall takes the position, and he's going to be Chief Justice from 1801 to 1835. 5 presidents come and go. He's there. Life tenure. And he does die in office. So one thing that Adams and the Adams administration does in the lame duck period between the election and the transfer of power is make John Marshall Chief Justice. They do some other things as well. Next slide. February 1801, they passed the Judiciary Act or Circuit Court Act of 1801. This is important. This creates 16 new federal judgeships, and these are courts of appeal. So what their idea was, we create a layer of courts between the trial courts on the federal level and the one Supreme Court. Very important courts. And it's new, and they're all processed, and they're all given their appointments to these offices, these new courts. The same law also reduces the number of Supreme Court justices from 6 to 5. Glitch in the Constitution, arguably. It doesn't specify how many justices. That's for Congress. Here, Congress is reducing the number. You could say an appellate bench should be an odd number of people to avoid ties, But you could also say, as Jefferson probably said, you're taking away the next president's next appointment, because when there's a vacancy, it won't be filled because we're going down a number, right? Jefferson's not pleased with that move. He's not pleased with the creation of new courts that are all going to be staffed by the Federalists either. A few weeks later, they also passed this Organic Act for the District of Columbia, which creates justices of the peace. These are insignificant, trivial, little, nothing patronage offices. The commission is for 5 years, and it's just like, traffic court judge. Nothing. And Marbury is one of these guys. This is who Marbury was. He gets one of these appointments. He doesn't actually ever get the paper that allows him to have the office, the commission, but he's one of those minor judges. In March, Jefferson takes office, and he comes to the realization of what the Federalists have done with the power they had left and the time they have left. He's already an enemy of John Marshall's. Marshall and Jefferson don't like each other, right? For a while, and for good reasons, they don't like each other. So Marshall's Chief Justice. There are new Federalists in high positions in the federal courts. There's patronage. He finds on the desk at the State Department several commissions of these justices of the peace, among them Marbury's commission, that haven't been delivered. They've been duly signed and sealed. The seal of the United States has been affixed by Adams' Secretary of State's office. That's John Marshall. But Madison isn't there yet. Jefferson said, well, I'm not going to have these delivered. He throws them away, basically. So Marbury never gets the paper to which he feels he's legally entitled. Madison gets there a few weeks later, kind of gets the sense of what's happened. And then Marbury spends the next several months running around trying to find out what happened to it, trying to get it, saying he has a legal right to it, that Jefferson and Madison are violating his legal right to this commission. And eventually, in December of 1801, he files a lawsuit. Now, he goes directly to the United States Supreme Court. He doesn't go to another court, a lower court. We are talking about events transpiring in the District of Columbia. He goes to the Supreme Court. He goes directly there, I think, because he reads a law that Congress passed in 1789. It's called the Judiciary Act of 1789. And a section of that law, Section 13 of the Judiciary Act of 1789, says that the court has the power to issue the kind of order he wants. It's called a mandamus. And a mandamus, it's the term that's still used, is an order to a public official to do that which that public official has a legal obligation or duty to do. He thinks the court can give him what he wants because Congress has said the court shall have the power to do that. So he goes and he asks for an order to show cause. That's a fancy legal term, order to show cause. Mr. Madison, you come, show cause why I shouldn't give Mr. Marbury what he says he's entitled to. So show up and defend yourself. The order is served. Madison doesn't show up in December of 1801. He ignores it, which is a statement in itself. Just no, I'm not recognizing this process. So what I think Marshall then would be doing with the court is saying, okay, we've had this much process. When we come back in June of 1802, we'll try the case, and we'll see what the merits are. We'll see whether you're entitled to it or not. We'll see whether the Secretary of State shows up or sends a representative to defend the lawsuit. But at that point, when they see that Marshall is intervening and is going to look into this case, and given everything the Federalists did before they left office, the Democratic Republicans counterattack. So slide 37. In March of 1802, they repeal the Circuit Court Act, which created all those important judgeships. Now, this is constitutionally controversial. There's an argument that it is unconstitutional to eliminate the offices of judges who are supposed to have life tenure. It was challenged in court. Marshall did issue a decision in the case where he said that Congress did have the power to do this. He didn't want to take on Congress on such an important matter, right? I don't have a really good sense of the legal merits of that question, honestly, but I just want to point out that it's a question. It's the only time that sitting judges have been removed by legislation in that way, abolishing the office. In April of 1802, they pass a new law about when the court can meet. And we tend to overlook the power Congress theoretically has to control the court by controlling how many judges, its jurisdiction, and so on. And it also determines when it meets. And it abolishes the June term, right? So it says you thought you were coming back in June, but you're not coming back in June. You're just going to meet once a year in a certain month, and that month will be February. So the Supreme Court won't sit again until February 1803. When they do come back, there is a trial and a decision in Marbury in the case. Secretary of State sends a few affidavits. They don't really defend. It's something between a default and a defense, but Madison certainly isn't going to come into court and participate in a trial. Now, another thing that the Democratic Republicans are doing, I didn't write this on the outline, I probably should have, is they're starting to use the impeachment power to remove Federalist judges. And it's largely just a shot, a threat, making it clear that this is something Congress can do. It can impeach officials. Can they do that for political motivations? Does it have to be outright illegality? And they did actually impeach and remove a crazy Federalist district court judge. I'm going to ignore that call. A guy from New Hampshire. And then they also moved to impeach a Supreme Court justice, the guy who had played the largest role in the sedition trials and was often pontificating off the bench. His name was Samuel Chase. And if they did impeach Chase, and eventually he was not quite convicted in the Senate, so that's a threat that's looming. I mean, so the Supreme Court is really on precarious ground. And here Marshall is with this case. What's he going to do? Is he going to order Madison to give Marbury his commission, suspecting likely that order would be ignored and undermining the power of the court? Is he going to cave in and say Marbury's not entitled to it, which is a violation of everything he believes and his principles? How does he handle it? And whatever you think of it, ultimately, it is kind of a very creative solution to the problem. The opinion in your book starts on page 40. Marshall organizes his opinion in Marbury under 3 questions. Now, even then, this is kind of irregular, right? Even then, a lawyer would say the question of jurisdiction comes first. Jurisdiction is the power to hear the case without regard to how you would decide it. For never mind who wins or how you decide it, do you even have the power to hear it? If you don't have the power to hear it, that's it. You don't have to say anything else, and you ought not to say anything else. That was the convention even then. It's certainly the convention now. So it's a little irregular that he flips that. He's going to address the merits first, and then at the end, he's going to be talking about jurisdiction, and we're going to have to go into some technicalities about original jurisdiction and appellate jurisdiction, and what the Constitution on Article 3 says, and what the Judiciary Act of 1789, Section 13, actually says. Because we want to check him out, right? He's going to say that a statute conflicts with the Constitution. Whenever a justice says something like that, you want to follow it and see if you think he's making sense. It's very hard to do in this case. I'm going to go through it. You may follow it, you may not. It doesn't matter that much. And then after he answers his 3 questions, he's going to be giving a very large, abstract, global kind of argument that the court does have the power of judicial review. So let's go through the questions. Slide 38. We have 3 questions. First, does Marbury have a right to his commission? Does he have a legal right to what he's asking for? And the answer is yes, of course he does. he's entitled to it. Marshall treats it like we're talking about a little piece of property or a bank account that Marbury has. It's a vested legal right. It's like a property right. And it's a legal right once it's signed and sealed, and the delivery of it is a ministerial legal duty that any official occupying the office has. Right? You have to deliver it. So the current Secretary of State, James Madison, has this legal duty, and he's clearly violated it. He hasn't delivered it. It's a legal question. Right? And there's an analysis of why that's the case. So we proceed to the second question, which is, if Marbury does have a legal right, can the courts provide him with a remedy? And the answer is yes. Let me rephrase it. In other words, in theory, the court could order the executive to comply with the law. That's a little dicey. A judge ordering a president or a secretary of state to do something. And here is another interesting aspect of Marbury. And I do think I forgot to introduce why we care about Marbury. Obviously, it's the first case of judicial review. It's known for that. First case where the court strikes down a law of Congress. Yes, it's that. But more importantly, it's a really fascinating case of the interplay or complexity of law and politics, right? What's legal? What's political? What's the court doing here? Should we understand what the court's doing in political terms? Where does the legal analysis fit in? And after Marshall asks and answers the second question, could we order the president to do something? You see on page 42 and 43, he's trying to construct that boundary. There is a domain, there is an area, there is a realm of discretion that's the president's and the president alone. Who are his ministers? What should he do in a certain area of foreign affairs? These things might be dedicated to him. He's answerable not to the courts. He's answerable to the people. Right? But there's another domain, another area that's legal, that concerns rights and concerns the rule of law. There, he has to be answerable to the courts. The rule of law depends on it. Right? Law is for courts. So he should be answerable if he's violating a right. Right? Where there is a special duty assigned by law, and individual rights depend on it. The right to resort to law, the laws of his country for a remedy, can't be questioned, and no one's above the law. Thomas Jefferson's not above the law. William Jefferson Clinton's not above the law. Nobody's above the law. So interesting way of him working that, creating that boundary, right, and making the courts supreme in if we can categorize and channel something into, the law. Now here's where things get really tricky, and most people teaching undergraduate courses wouldn't worry much about this. Third question, right? So if Marbury has a right to the commission, and if in theory the courts can order the president to follow the law and order them actually to do something, give him his commission because he's legally entitled to it, why doesn't Marbury get his commission? Why doesn't Marshall order Madison to give Marbury the commission? Third question, if Marbury has a right, and if the courts could afford him a remedy, is that remedy, there are two parts to this third question, is that remedy an order of mandamus from this court in this case? No. Why? Because we don't have jurisdiction. Why don't we have jurisdiction? Well, Marbury came right to this court to start the case, so we are exercising original jurisdiction. Jurisdiction is the power to hear the case. Do we have it? Original jurisdiction is the power to hear the case in the first instance. Appellate jurisdiction is the power to hear the case after another court has decided it. It's reviewing power, appellate jurisdiction. Article 3 of the Constitution, I'm going to slide down to slide, I've put all of Article 3 in the slides, but I'm going to slide down to slide 42. It's the relevant section. That part of the Constitution itself, Marshall is arguing, tells me when I have original jurisdiction and when I have appellate jurisdiction. In all cases affecting ambassadors, other public ministers, and councils, and by the way, Madison is not one of those. Everybody understood that language to mean foreign officials. So in cases involving foreign officials, or those in which a state is actually a party to the litigation, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, with such exceptions and under such regulations as Congress shall make. Okay, he's interpreting, I hope you're looking at that language on slide 42. He's interpreting that language to say that the Constitution tells me I have original jurisdiction in these kinds of cases, and only these kinds of cases. And Marbury's case doesn't fit in one of those boxes. It's not one that's specified here. We could quibble with him about how he's reading Article 3. There is a comma with a clause that says Congress can make exceptions to these stipulations. Whether Congress's modifying power reaches the whole language or just the appellate jurisdiction would be a question. He says it would make no sense to say original in XYZ cases, appellate and all other, unless you really meant X, Y, and Z and no others. Okay, let's assume he's right, that Article 3 tells the court when it has original jurisdiction. Marbury's case is not one of those, so the court then would lack original jurisdiction. Right? If we assume he's right, then the conclusion is right. The court does not have jurisdiction. Can't hear the case. Okay, I've spent a lot of time telling you what I think of Madison and Jefferson. But anyway, I can't hear the case. Note that he doesn't stop there. He takes an extra step. The extra step is to say that there is a law of Congress passed in 1789 that gave me original jurisdiction, that told me I could hear Marbury's case. But that law conflicts with a higher law, Article 3 of the Constitution, and I have no choice but to strike that law down. Yeah, sure, that law gave me more power than I had. It gave me original jurisdiction I didn't have, gave me original jurisdiction to hear Marbury's case. But I can't accept that power, that ordinary law of Congress, because it conflicts with the Constitution. I must strike down that law. Nobody cares about that law. Nobody's going to be upset when it is invalidated. But the question is, does that law really conflict with Article 3? And the next slides, 43, 44, 44 particularly contains the language. You can read it all if you'd like. It's very hard to make sense out of, but does it really conflict with Article 3? And as I look at slide 44 and I see the power to issue a writ of mandamus, I don't see anything about original and appellate jurisdiction. You could imply that the grant of the power implies original jurisdiction to issue mandamus. You might read it the way he reads it. I don't know. I just don't see it. So what I think he's doing is he's stretching the meaning of the statute a lot to make it conflict with the Constitution so that he can invalidate it. All right. And, you know, we could say a lot more about what the Judiciary Act means or doesn't mean and whether he gets it right or not. I don't think there's a strong case that it actually says what he says it says. So what is he doing? And should we admire it nevertheless? Does our admiration for what he's doing depend on whether we think he's reading Article 3 and the law of Congress correctly and that they are actually in conflict? All right, so slide 45, we're almost done, slide 45, asking some questions. What's really going on here? I'm sort of specifying. There's one more big piece of this that we have to do. There's one more big move. After he makes that argument, on page 46 and 47 and 48, actually it starts on page 46, the authority therefore given, right? It's a very abrupt shift to, do we have the power to strike down a law of Congress if, as I've shown you, it conflicts with the Constitution? Of course we do. And I've listed the points I think he's making there. And this is Marshall's style, a series of arguments, one after the other. You feel like you're being pummeled. The first big move is, hey, this is a written constitution. This is a brand new invention. We invented it here in the states, in the colonies. And writing it down implies limitation. Writing it down implies higher fundamental law. And that means nothing unless courts can enforce those provisions against ordinary legislation. The people's representatives are not the people themselves. The people themselves is spoken in the broadest, most fundamental terms in the Constitution. There's a text, it's written. Judicial review is implied there, he says. He doesn't even look at Article 3 yet. Never mind what the Constitution says. The very written nature of it implies that what it means will be for the court to interpret when that's put in issue in a case. Does that really follow? And does it follow because the Constitution is written law like any other law? That's the invention he has to actually achieve, right? Everybody agreed that the Constitution was higher law, but it was a new idea that it was the kind of law that the courts could work and interpret and parse in the way they worked and interpreted and parsed ordinary statutes. Next, he turns to Article 3. Article 3 does not say the court has the power of judicial review directly, expressly, but it does say that the judicial power extends to cases and controversies arising under the Constitution. Marshall says, well, why would you say that if I can't actually look into the meaning of the document, right? Cases do arise under the Constitution. I have to read it. Next, he moves to the clear case, right? So the Constitution does include provisions that look like rules. The president must be a natural-born citizen and 35 years of age, no ex post facto laws. To be convicted of treason, you need the testimony of 2 witnesses in open court. What if Congress passes an ex post facto law or says 1 witness is okay? Obviously, I have to enforce the Constitution in a clear case. Okay. If I concede the clear case, do I then necessarily concede the case where reasonable people disagree about what the Constitution means? About whether something is or isn't commerce among the states, for example. Are you convinced by that? His next 2 points are kind of weak. There's the supremacy clause. That doesn't tell us anything about the Supreme Court's particular power. The Constitution and treaties and laws passed pursuant to it are the supreme law of the land. That's in Article 6. Judges take an oath to uphold the Constitution, he says. Okay, so does everybody else. Not much of an argument. And this brings us to the bigger questions. What's going on here with respect to law and politics? Do you admire what Marshall is doing? Robert McCluskey writes, the decision is a masterwork of indirection, a brilliant example of Marshall's capacity to sidestep danger while seeming to court it, to advance in one direction while his opponents are looking in another. Yeah, everybody's looking to see whether he's going to take on Jefferson and fight with Jefferson and Madison, and he ducks that. He doesn't order them to do anything, but he establishes the precedent that the court can apply the Constitution to strike down a statute, even if it's an insignificant statute in this instance, right? That's a good thing. McCluskey thinks it's a good thing. He thinks that the court has a vital role to play if it understands what it is and how to play it, right? But that's important in our development. You don't have to agree with that. One wonders what Marshall himself would say. Does he know what he's doing? Does he think he's following the law? And the next piece of what we're going to do is we're going to look at McCluskey's writing and talk about Marshall's efforts to build the court as an institution, to prop up its legitimacy, to establish its authority, to bide its time. The court's not going to strike down another law of Congress until 1857 in the Dred Scott case. After 1810, it will be busy striking down state laws and propping up the authority of the national government for several decades. Okay, I'm going to wrap it up here. Again, I'm sorry all of this took so long. We will use videos, probably, hopefully sparingly. Hopefully you won't have to look at such a gruesome face next time. But I think it might be a useful way for us to cover some material without taking class time. So I'll probably create a couple more over the next week or two, one on the basic themes and things to think about in McCluskey's book. It's a very important book. And maybe a lecture on the McCulloch case itself. We'll leave all the Dred Scott materials, and there's some really interesting stuff to go along with the primary source materials there. So thanks very much, and thank you for your patience. Bye.